Time, sir. Thank you.
Thank you.
All right. The final case of the morning would be Llano Financing Group versus Kellogg et al. Yes, sir. I've got you down for 5 minutes of rebuttal. You want a different amount?
Not that I know of, but maybe I'll just stop early.
Gotcha.
May it please the court. Robert Hauser, West Palm Beach, for the appellant. The issue, I believe, is statute of limitations, because this is a complaint that was dismissed out of motion to dismiss before an answer was filed as a matter of law, and the only issue that was argued below at the hearing was statute of limitations. So I'm going to tackle that.
And you agree it's the 4-year statute of limitation. I mean, that's not an issue in this case. It's the 4-year statute.
That's our position, yes, sir. And I think it has to be because we're not in privity with the professional. If we had been in privity with the professional, it would be 2 years. And interestingly, in this case, even the original lender was not in privity with the professional, because this is a common situation where a homeowner takes their case to a broker. It's the broker that hires the appraisal, and then the appraisal is shopped to various lenders. So the original lender receives the appraisal not as the client, but as a recipient who's expected to consider it. As original lenders are apt to do, they make a loan, and then as original lenders are apt to do, it sold the loan. And so my client stands in the shoes of this huge number of secondary market purchasers out there who take mortgages under the assumption that the appraisal and underwriting therein is correct. And it would be really something if secondary market purchasers were told, sorry, you can't rely on that appraisal, and now you need to underwrite the loan every single time the mortgage is transferred on the secondary market through, for example, Fannie Mae or Freddie Mac or some other lender. But on the limitations issue, the other side admitted below that the statute of limitations, I need to back up a little bit, in the context of a lender or its assignee making a claim for professional negligence against a real estate appraiser due to an alleged overvaluation by the appraiser in connection with the lender's origination of a mortgage loan, the statute of limitations begins to run when the property sells for less than the purported appraised value, because it is at this point that the harm from the purportedly negligent appraisal occurs and the cause of action for negligence accrues. You will find that at page 126 of the record in their motion papers. And I completely agree with that statement of law. It is our position that the statute of limitations does begin to run when the property sells for less than the appraised value. That happened here at the end of 2011 when my client took title, and our complaint was filed, I believe, in the middle of 15, so we're timely under the 4-year statute. Now, the reason...
Basis of the judge's decision, though?
No, sir. At the argument, the other side convinced the judge that the limitation period begins far earlier. But the reality is what the other side conceded beforehand has to be correct. And there are other cases that deal with mortgages that support our position.
And you say it's that then it's at the time of foreclosure because that's when they're damaged?
Right. That's when it's possible to know what the damages are through judicial decree.
Because they're damaged when they make the loan, right?
Well, no, sir. There's a speculative argument.
Okay, I loan you $1 million and take as collateral property that I think is worth $1 million, but it's only worth $500,000. I haven't been damaged at that point?
Well, no, sir, because I believe that you're making payments to me on a monthly basis, and I'm happy.
Could you, if you found out the next day that, if I found out the next day that the appraisal was wrong, that I actually loaned you $1 million on a piece of property that's only worth $500,000, could I sue you the next day?
I don't believe so, and here's why.
You can't sue, you couldn't
Because
sue
you
on
have
that, huh?
recourse, I have recourse against Your Honor as the borrower, and I may succeed in collecting, and first of all,
Well, if I screwed up the hypo, I apologize, but the point is that if the lender discovers the very next day that the appraisal is inaccurate, the day after the lender makes the loan, is it your position that the lender may not then bring an action against the appraiser for negligence?
no, sir, actually, that cause of action would be premature
Premature until when?
until the
How long
loan.
does the lender have to wait before the lender can bring an action when the lender knows now that the lender made a loan on property based on a false appraisal?
It would be at foreclosure, because we need a judge to come in
So the
and,
borrower quits paying.
right, which he may never pay.
And you got some decisional law on that, says that that would be a premature suit.
I think the Kipnis case requires that, sir.
Hipman case?
Kipnis, Kipnis.
Yeah, I'll look at that.
So, but that's not a mortgage case. The mortgage cases that are, the best mortgage cases for us are, for example,
You
Zuckerman.
have a case that says that the lender has to wait, even though the lender knows that it's a false appraisal.
Well, I've got some great cases on that issue. For example, RSB. The RSB case,
All right, now, if you give me the name of the case, I'm going to look at it, but if I start reading it and it doesn't say what you said it says, I'm going to put it aside.
all right, let me give you,
Does it say that a lender has to wait, a lender makes a loan based on appraisal that's false, that the lender can't sue until the borrower defaults, there's a foreclosure, and then there's a deficiency determination?
I think that result is compelled by the RSB case, Zuckerman, and Kipnis. Okay, so I'll tell you why, because I'll tell you the facts of those cases. RSB is a legal malpractice case where there's two sets of malpractice plaintiffs. Okay, malpractice plaintiff number one is a company, and as a result of malpractice by their lawyers, the entity loses property. Okay, and that judgment was affirmed by the U.S. Court of Appeals. Okay, so the company right then and there has a crystallized legal malpractice claim against the lawyers, no question about it. But there's also some individual guarantors who are going to be liable for a deficiency, okay? And they know that the lawyers have committed malpractice right then and there, sort of like the example that Your Honor is giving me. There's no question about it. The property's gone in foreclosure, and by contract, they're liable for the deficiency judgment. But there hasn't been a deficiency judgment entered yet. And so what the Fourth District did, the Fourth District threw those plaintiffs out of court and said they were premature. Because even though they knew there was malpractice, and even though they knew how much there were, presumably it was possible to measure the market value of the property versus the amount of the loan, and thereby calculate a deficiency judgment, the Fourth District threw them out of court and said they were premature. So yes, I believe under that logic, my plaintiff would be thrown out of court and told that they're premature until the property settles. And again, the case cited by my opponent, it's a federal case, so it's not binding on this court, but they cited the Klein case on page 7 of their memo, which is on 126 of the record, as support for the proposition that the limitation period begins to run when the property sells for less.
So the lender takes, makes the loan and takes collateral, if you will, right?
Yes, sir.
They find out the next day or the next week that the collateral that they thought covered the loan doesn't cover the loan. Are you suggesting that what you're saying essentially is that the collateral doesn't matter, they're not damaged by the fact that they have, that the value of the collateral doesn't cover the loan?
Well, the problem, Your Honor, is that the vast majority of these loans, the borrowers continue to pay their mortgages.
Well,
They
but that's
never go
not the
into
issue,
foreclosure.
right? But that's not the issue, because that assumes that there's no value to the collateral, right? I mean, if there's value, if the lender sees value in having the collateral that covers the full amount of the loan, and then they find out it doesn't cover the full amount of the loan due to negligence, why are they not damaged? Why is that the lack of collateral in that case? Why is that, or the reduction in what they thought the value of the collateral was, why is that not a damage to the lender?
Because, well, it's that there's no way of knowing a quantity. There's no way of measuring it.
Sure
okay?
there
Because
is.
You just
get a
said there
true
was.
appraisal. You get a true appraisal of the actual value. You got the negligent appraisal. You compare the two, you got the damages. It's quantified.
But what if the borrower pays the note for the life of the loan? And that's for
That
example.
doesn't account for the fact that the lender still doesn't have the benefit of their collateral. Would you agree there's value to collateral in these transactions?
Right, but nobody knows what it is. The value of the collateral becomes relevant in a foreclosure situation because a judge enters a deficiency judgment.
Didn't you just say, though, that you said RSB, what was the case you cited? What was
Yes,
the case?
yes.
Didn't you just say that presumably they could have determined what the deficiency judgment would be?
Right, and the courts didn't require it.
Well, how do we, I mean, if they could determine what the deficiency judgment would be, why couldn't they also determine what their damages are when they find out their collateral?
Because it wasn't fixed by the judge, it wasn't fixed by the court. And the same happened in the Zuckerman case. In the Zuckerman case, the lender, Mr. Zuckerman, held a secured note that was signed by the borrower but not his wife, and it happened to be homestead property. And so he wanted to bring a legal malpractice claim against his lawyers, and the third district held that merely knowing that you have a worthless mortgage that isn't signed by the mortgagor's spouse is not a cause of action. You have to wait until a judge says that that mortgage is worthless. And there's another example where I think in theory that lender could have gone out on the open market and said, look, I've got this mortgage that's impaired. Will you please buy it? And I think you could make the argument that they were obligated at that point to say, hey, I own an impaired mortgage. It has some value, and therefore I should be able to sue the lawyer at that time. And the court said, no, you may not sue the lawyer at that time because you don't have any damages. You won't have any damages until a judge fixes the deficiency. And then in the Kipnis case itself, which is not a legal malpractice case, in fact, it's a case involving virtually every tort and statutory claim there is out there for deception. It was known in 2006 that the defendants, who are not professionals and are not subject to the professional liability statute in Florida, it was known that the defendants had committed essentially tax fraud and giving advice to clients to do transactions that are called card transactions in the opinion. Okay, so they enter into an agreement, a deferred prosecution agreement with the United States, and I think it was in 2007. And yet, those plaintiffs were not obligated to bring their suit until 2012. And the reason is that even though they knew they were the victims of a fraudulent scheme, their case in the United States tax court over how much penalties and taxes and interest, if any, they were going to have to pay was not yet settled. So there's another example where actual knowledge that somebody messed up. In that case, it's a non-professional, subject to the same 4-year limitation period that I'm exercising here. The non-professional was subject to damages accruing with a final judgment of the United States District Court. It might have been tax court. So,
In Kipnis, did they try to litigate during the pending litigation whether or not it was indeed a valid tax shelter?
yeah, the taxpayer was arguing that.
Right,
That-
so
that
if,
even-
and if the taxpayer had prevailed,
Of course.
then the IRS would have to go home.
Yes, exactly like
So there's
my,
it's not a question of value, it's not whether it's a good tax shelter or not, it's whether it's a tax shelter or not.
But it's
Here, your position is, this is a crummy appraisal from day one, because whatever the reasons are, and it's never gonna get any better, it's just a question of how much you lose. That's not what Kipnis was.
But we
Kipnis was, do we have a bad tax shelter? Do we have a tax shelter or not? Until the final decision, you don't know if you are damaged at all, correct?
well, Your Honor, I think Kipnis is similar to my case because in Kipnis, there was no question that there was a fraud by the defendant, okay? And the taxpayer had to spend a fortune to try to get out of this fraud. And of course, they were arguing that I should be allowed to keep the deduction even though the company that got me into this transaction is a bunch of fraudsters. And the Supreme Court said that cause of action was premature because you don't know whether there are any damages yet. And in my case, yes, even if, no, I'm not asserting that the secondary market borrowers know that these appraisals are flawed. They don't even investigate them until it's necessary because there's a default situation. But even assuming hypothetically that they could know there was a problem with the appraisal, they're happy with the products because the borrowers are paying. And remember, there's a certain window of being upside down on a loan. If the borrower pays down the loan to a certain point, they're no longer upside down. So
If I hire somebody to appraise a diamond, and I'm going to buy a diamond, and it's a false appraisal, and I overpay on the diamond, right then and there, I'm harmed. I shouldn't have to wait until I try to resell that diamond to figure out, now here's how badly I've been harmed. Much less here in the mortgage situation. If you have the idea, or knew or should have known that it was a fraud or a false valuation, you know, as Judge Torpey was saying, you got to sit there and sweat for the next 29 years and 11 months to see if the guy's going to pay it off or not.
But in reality, a mortgage is merely a contingent right to take property if there's a default. Most of the time, the mortgage just sits there harmlessly. So the mortgage really only becomes relevant when there's a default. And in your diamond situation, it's not like I have a mortgage on the diamond. The diamond is in my hand. So it's distinguishable, and it's not like I came in with this distinction. The other side conceded that the limitation begins to run for the original lender when there's a foreclosure sale.
It's not the basis of the trial court's decision that you're appealing, is it?
Of course not. Right. I'm pointing out that the other side concedes that the trial judge was wrong. I need to use the rest of my time for rebuttal. Thank you, Your Honors.
Well, you only get rebuttal if he argues.
Fair enough.
You understand that, right?
I saw that in the previous argument. Understood.
Does anybody have any questions for counsel for the appellee? Nobody's got any questions for you.
Morning, Your Honors. May it please the Court, Alex Toronto on behalf of the appellees, Mrs. Tunnock, Mrs. Kellogg, and Appraisal Experts, Inc. I hear what the Court is saying. In fact, I struggle with the decision whether to even argue anything at all because we believe it's so clear. The only thing I would like to mention is to, one, clarify the record, and two, to answer the direct question that Judge Torpey asked the appellant, which he did not answer. First, to correct the record, the appellees in this case below never agreed or never conceded that the statute of limitations applies when the property is sold. In fact, we only did so when we were arguing that a professional malpractice statute of limitations could apply, not ordinary negligence. And again, in record page 126, right before he highlighted the language, it says, when making a claim for professional negligence. The second point I would like to bring up is to answer your question, Judge Torpey. And the direct answer is no. Not a single case exists that states that for a lender to have a cause of action against a negligent appraisal, there has to be a foreclosure. Not a single case. RSB doesn't say that. Zuckerman doesn't say that. Kipnis surely doesn't say that. And in fact, there is a case decided last week against this very appellant by the first DCA, and we filed our notice of supplemental authority that says, and this is the Pettit decision, nobody had to wait for a foreclosure to address that injury. That injury being the collateral and diminution of value of that collateral. So again, if there's no further questions, I have nothing else to add in this case.
All right. Thank you, sir. Okay, he argued, so you get your rebuttal time. Fire away.
Yes, sir. So I'll try to address just a couple of points. Yes, the Pettit decision came out last week against me, but that's the first DCA, and that's just a panel, and they're following their Kellermeyer decision, which I think is in tension with Flumberg and Pete Marwick and Kipnis and Zuckerman RSB. So I understand why a panel of the first DCA followed a previous panel of the first DCA, but this is the fifth DCA. And I guess his other point was not a single case. Well, not a single case, except I don't understand how their concession in their papers is reconcilable with their present position
Well, they were arguing that in the context of the professional negligence statute of limitations, which may have a different trigger.
And until November of 16, I thought that might be correct. But Kipnis blew that away, because Kipnis applied that same final accrual rule, which we use in professional cases. It applied it to a case that is unquestionably not professional, right? What happened in Kipnis was banks.
You took that as you represented to the court that the admission, this was an admission by the appellee, that the statute of limitations on a negligence claim commences to run from the time of the foreclosure, which is not what they were arguing at that time, right?
Well, I'm arguing it's professional negligence.
They weren't arguing it in the context of the 4-year statute of limitations. Below, they were arguing.
They were saying, I think they were saying, but this is 2 years, so you lose.
Right.
But they still made the statement of law. The court's free to read it
Made the
without
statement of law as it related to the 2-year statute of limitations.
Yes, and they hope to distinguish that admission by saying that it's 2 years. But I think we now agree that it's 4 years. And so the question is, do we get the benefit of final accrual in a 4-year situation? And I submit Kipnis answers that question now in a way that I might have answered it differently before November of 16 when Kipnis came out, because Kipnis has blown away the distinction between professional and non-professional negligence accruing, right? I mean, they basically gave those plaintiffs the maximum benefit of a quasi-discovery rule, even in a non-professional context. So that's all I have. Thank you, Your
All
Honors.
right, thank you all. Have a safe trip back home to South Florida. All right, we'll be in recess.